Well, welcome to Landmark Chambers and the Withdrawal Agreement and EU Settlement Scheme webinar. We're delighted to see so many of you joining the session today, and we hope you'll find the sessions helpful and interesting. My name is David Blundell KC. I'm going to chair today's session, and I'm joined for it by my colleagues Galina Ward KC, Julia Smyth, and Charles Bishop, all of whom I will introduce in just a moment. So over to the webinar itself. As I say, I'm delighted to see so many of you attending this morning and from such a wide range of organisations. A great many of you have worked with us at Landmark before. For some of you, it may be the first time engaging with us at Landmark. Either way, a very warm welcome to all of you. This is actually the first of two EU seminars we'll be running on EU law this term. This one is focusing, as you know, on the Withdrawal Agreement and the EU Settlement Scheme, with a particular focus on citizens' rights issues. The second, which will be chaired by my colleague Tim Bewley KC, will be a more general EU law update. We first had the idea of running a series of seminars on EU law with particular focus on the Withdrawal Agreement in its very early infancy, but we felt it was perhaps more valuable and of more interest to all of you to wait until we had at least some judicial consideration of the agreement's provisions and the UK's approach to it. We're now almost exactly 4 years on from the signing of the Withdrawal Agreement. The final version was signed on the 19th of October 2019, and almost 3 years on from the end of the transition period on the 31st of December 2020. That period has, at least as far as I can see, flown by. There have been a number of very significant cases on the Withdrawal Agreement in that time. Domestically, we've had the IMA decision of Mr. Justice Peter Lane, the Court of Appeals decision in Selleck, and we await, of course, with bated breath, the decision of the Court of Appeal in the AT litigation. In Luxembourg, of course, we've had the CG decision that Julia and I were involved in, and more recently, the Préfet du Gers decision as well. All those cases raise a host of interesting but difficult issues. We've only really just begun to scratch the surface in relation to the Withdrawal Agreement and the settlement scheme, but already the courts, both here and in Luxembourg, have given us an awful lot to think about. And we've been fortunate, as I say, to be involved at Landmark in many, and indeed most of the major litigation on the the UK's withdrawal from the EU since the very earliest days following the referendum. I was part of the UK team in the early RO case on the European arrest warrant and the approach to UK obligations post-referendum but pre-withdrawal. Julia and I and Richard Drabble KC were all involved in the CG case on pre-settled status and benefit rights, all in the CJEU. Galina and Charles were both instructed for the 3 million as interveners in the IMA case, and Galina recently acted for the IMA itself in the Selleck case. And Charles, I know, is involved in a number of the ongoing cases in this field. So who better to lead us through all those particular issues than the speakers? Let me say a little bit about each of them now. Our first speaker this morning will be Julia Smyth. Julia will be very well known to many of you. She's a true expert on all matters of EU free movement law, but especially the Withdrawal Agreement, the settlement scheme, and associated citizens' rights issues. Indeed, she has been instructed, I think, literally in all the main cases raising citizens' rights issues, and her general all-round brilliance was recognised last year when she was voted Human Rights and Public Law Junior of the Year at the James and Partners Bar Awards. I've worked very closely with Julia over a number of years on EU and public law issues, by which I mean to say she's worked very hard on them, and I've simply repeated what she's told me to say in court. But this morning you'll hear from her directly, which is a much better experience. Galina, if you read Galina's profile, you might reasonably come to the conclusion that there is literally no area of law she cannot master, and she's recommended by all the directories across the board, from property law to public law and everything in between. But she's been particularly litigating for a number of years now about citizens' rights issues under the directive, initially in the context of social security, healthcare, and higher education in particular. And since taking silk last year, she's acted for interveners in many of the leading withdrawal agreement cases, including the IMA litigation for the 3 million, as I indicated, the AT litigation for the Air Centre, and the Selic case for the IMA on that occasion. Charles, despite joining Chambers only in 2020, has already been involved in a number of the leading cases across all our areas of practice. He specialises in public law alongside planning and environmental law. And with Galina and the Public Law Project, he represented the 3 million, as I've already said, in the IMA's challenge to the government's implementation of the withdrawal agreement. He regularly advises on strategic issues relating to citizens' rights and retained EU law. And before coming to Landmark, he worked as a paralegal at Wesley Grick Solicitors and at ILPA, leading on their response to Brexit. So you've got 3 speakers this morning with very real and genuine expertise and experience in this field. Well, with that introduction, I'm now going to stop talking and I will hand over to our first speaker, Julia, and she will talk to you about some key cases and themes relating to citizens' rights so far. Julia, over to you.
Thank you very much, David. If you can't hear or see me, somebody will let me know, but I hope you can. Welcome, everybody. It's lovely to have you here. I'm not sure I can stand up to that description of me that David given, but I will try to, in 20 minutes, I could talk about all of my bullet points for the whole 20 minutes. So what I'm proposing to do is to give you an overview of some of the key themes and some of the key cases. Oops. So, as David's already said, we've had some time, both after the signing of the withdrawal agreement and after the end of the transition period. And I'm sure many of these provisions will be familiar to you, but I was just going to spend a little bit of time talking about some of the key provisions and some of the most controversial, at least in the litigation to date. So, part 1, common provisions. The key provisions of interest for citizens' rights are probably Articles 2, 4, 5 and 6. And I will just deal briefly with a couple of points. So Article 2 contains a definition of union law, which includes the Charter and general principles of EU law. But importantly, because it's just a definition, it doesn't mean that the withdrawal agreement applies EU law generally. Essentially, that definition is only engaged if there is a reference to union law in the withdrawal agreement. Now, that makes it all sound very easy, and as anyone who is involved in litigating these cases knows, it is actually not always clear when EU law is being specifically applied and when it isn't, and that's one of the issues in the AT litigation. And the other point, just to note in passing, is that union citizens and UK nationals are separately defined, which reflects the fact that, of course, UK nationals are no longer union citizens. The other interesting provision to mention is Article 4. Again, controversy in the cases about Article 4. So Article 4.1 says the provisions of this agreement and the provisions of union law made applicable by this agreement shall produce in respect of and in the UK the same legal effects as those which they produce within the Union and its member states. And the key question there is, does that mean the same substantive outcome, or is it just talking about things like direct effect? So watch this space. And then again, one of the other key provisions is Article 4.3, again live in the AT litigation. And Article 4.3 says, the provisions of this agreement referring to union law or to concepts or provisions thereof shall be interpreted and applied in accordance with the methods and general principles of union law. Now, as I'm sure you all know, the general principles of union law include things like proportionality and also fundamental rights. Less clear, the methods of union law. The upper tribunal in AT found that that included the Charter. The government doesn't accept that. And another difficult question is, when are the provisions of this agreement being interpreted and applied? And again, that's live in the AT litigation. So I'll come back to part 2. Part 4 deals with the transition period, which generally applied EU law subject to some exceptions, and also dealt with references during that period. And then the key provision to mention in part 6 is Article 158, which deals with references after the end of the transition period, and I will come back to that later. So again, just to give a bit of a whistle-stop tour of the citizens' rights provisions in the withdrawal agreement, just to navigate yourself, there are 4 titles. So some general provisions, very important, in Articles 9 to 12. And then Title 2 deals with rights and obligations. Title 3 deals with social security coordination. And then Title 4, other provisions. Again, important provisions there. And I'm just going to spend a little bit of time on some of these provisions. So Article 10 sets out who is within scope of the withdrawal agreement, and various unanswered questions there about what that means. So there's Article 10.1, which deals with union citizens, essentially, and UK nationals who were exercising EU rights of residence in accordance with union law before the end of the transition period. And then there's a requirement to continue to reside there thereafter. What does that mean? Does that mean that people can fall out of scope if they're not complying with the conditions, and so on? And then Galina will talk more about Articles 10, 2 and 3, which deal with extended family members. Article 11 deals with continuity of residence, and that says that continuity of residence for the purposes of Articles 9 and 10 is the scope provision, shall not be affected by absences as referred to in Article 15.2. Again, that indicates that a person can fall out of scope if they don't have continuity of residence. And unlike the old days where you could trigger EU law rights simply by moving, you won't be able to do that anymore. So again, a watch this space provision. Title 2, Article 13, considered at length in the IMA judgment, but that basically sets out the circumstances in which people enjoy rights of residence, and it also prevents states from imposing limitations or conditions on obtaining, retaining or losing residence rights other than those provided for in this title. Now, one of the issues in the AT case is in Article 13.1, where it says EU citizens and UK nationals shall have the right to reside in the host state under the limitations and conditions as set out in Articles 21, 45 or 49. Does that mean that the right in Article 21 survives? And if so, how does it survive? Because clearly not all of Article 21 can survive, and I'm sure you all know Article 21 is the free movement provision in the treaty. But the founding right for that right of free movement is in Article 20 of the treaty, which is the union citizenship rights, and that doesn't, of course, survive the withdrawal agreement. So interesting questions about Article 13. Articles 15 and 16, permanent residence, which are considered in the IMA judgment. And then Article 18, very important. This is a big change, or perhaps not such a big change, from the position under EU law, because under EU law you could not require people to obtain residence documents unless they were extended family members, because residence documents in EU law are not constitutive of rights. They're simply declaratory. But Article 18 introduces a new right for a host state to require people to apply for a new resident status, which confers the rights under this type of withdrawal. I could do a whole talk just on this article, and you'll be happy to hear that I won't be doing that. But I will just touch briefly on what does that actually mean when I deal with the IMA case. Article 20 is all about criminality, and again, a headline point here is that it's different for conduct before and after the end of the transition period, even for those who are exercising rights under the withdrawal agreement, they've got a right of residence. So, for example, somebody who's working, their post-transition period conduct gets judged by the domestic law test if being deported. And then social security coordination, anyone who has had the good fortune to be involved in dealing with social security coordination will know just how complicated this is. I'm not going to talk about it, you'll be happy to hear. And then finally, the other provisions in Title 4, Articles 37 to 39. Article 30 permits states to introduce more favourable provisions under domestic law. Again, issues about quite what that means, because it reflects a similar provision in the directive, which was addressed in CG. And then Article 39 provides for lifelong protection unless somebody ceases to meet the conditions set out in the titles of Part 2. Again, I suspect further down the line, there will be litigation about what that means in practice. So what have the courts had to say about all of that so far? Not a huge amount, although at the same time, a huge amount, because each case raises a huge number of potential issues. And we are only, I think, at the beginning of seeing these issues coming through. So the Préfet du Gers case, that was a case about whether a UK national residing in France could still rely on union citizenship rights. Unsurprisingly, the court said no, they could not. But that's, if you want to have a look at some of the thoughts of the ECJ on the withdrawal agreement, it's an interesting read, both the Advocate General and the court. And then CG, as David mentioned, that's not a case about the withdrawal agreement, it's a case about the transition period. The key question in the AT litigation, which I'll come to, is to what extent that judgment applies after the end of the transition period. Now, for anyone who isn't familiar with CG, it was somebody who held pre-settled status under the EU settlement scheme, and she made a claim for universal credit. And that claim was refused because there is an express exclusion in the benefits legislation for those with pre-settled status who don't enjoy a right to reside under EU law. So if you have pre-settled status and you're a worker or some other relevant right of residence, you will qualify. But if all you have is pre-settled status, the intention was to reflect the position before the end of the transition period, when CJU case law was quite clear that you couldn't qualify for benefits. Now, CG is really in two parts. The first part of it is to say, well, that case law still applies. In other words, that CG could not rely on the anti-discrimination principle in order to access universal credit. But it goes on to say that in granting a more generous residence right under domestic law, the UK was implementing Article 21 of the treaty, and therefore the Charter applied. It then went on to say that because CG was a mother of 2 young children with no resources to provide for her own and her children's needs, and she was isolated on account of having experienced domestic violence, because the Charter applied, the national authorities could only refuse an application for social assistance after ascertaining, and I'll read this, that refusal doesn't expose the citizen concerned and the children for which he or she is responsible to an actual and current risk of violation of their fundamental rights, as enshrined in Articles 1, 7 and 24 of the Charter. In the context of that examination, those authorities may take into account all means of assistance provided for by national law from which the citizen concerned and his or her children may actually and currently benefit. What does that mean, both before the end of the transition period and after the end of the transition period? Does that reasoning even apply after the end of the transition period? Those are all issues which are live in the AT litigation. There's a judgment from the upper tribunal, the reference is on the next slide, which decides the case Secretary of State. There have been 2 hearings in the Court of Appeal, one in March and then a further hearing yesterday. which some of us were at. And that hearing was live streamed. So if anyone is interested, it should be available. Essentially, it's anticipated that a judgment should be available fairly soon, but there is no date as yet. And then finally, Selleck, which Galina is going to talk about, is a case about extended family members. Galina and I were involved in that case. Again, an interesting judgment, and also expressly leaves some issues undecided, and I will let Galina deal with that case. The administrative court in the IMA case, which David and I did, Galina was also involved in that case. The Commission was also involved in that case. So I don't know if it's happened before, that particular case, but the Commission intervened, was an interested party, and also made written and oral submissions. So what was that case about? The IMA's case was that it was contrary to the withdrawal agreement to require a person with pre-settled status, and to be clear, this was about a person with pre-settled status, but who also fell within scope of the withdrawal agreement and was exercising residence rights under it. Their case was that it was unlawful to require that person to make a second application under the EU settlement scheme, either for settled status or for a new period of pre-settled status when their pre-settled status expired without qualifying for settled status, that was unlawful under the withdrawal agreement. And Mr. Justice Lane agreed. He said, essentially, once an initial application is made under the EUSS and under Article 18, what that means is that you've got through the gateway. So one of the key questions, and I mentioned this earlier, is, well, what is Article 18 really doing? Is it what's often described, although I can never say it properly, as a contributive scheme? Is it really introducing something like the UK system of leave, or is it doing something different? And the IMA and the Commission said, well, actually, what Article 18 is doing is allowing the member states to impose a requirement to apply for a gateway status or a beneficiary status. So once you've got that status, you've got yourself through the gateway, but that's it. Whether or not you're actually enjoying rights to reside depends on whether or not you're meeting conditions in the withdrawal agreement. So what you have to do is separate out the domestic analysis, which is to look at the leave, and the EU position, or the EU position, or the withdrawal agreement position, which is to look at, right, under the withdrawal agreement, have you got this beneficiary status? And then are you complying with the conditions of EU law, which are applied by the withdrawal agreement? And similarly, is the host state complying with those conditions, or is it imposing conditions which it should not be? So the important thing to have in mind, the takeaway, is that Article 18 just envisages a gateway status, and a person cannot be required, or to make a second application. They will enjoy rights directly under the withdrawal agreement if their pre-settled status expires, but they still have direct rights under the withdrawal agreement because they're meeting its conditions. So that was the IMA judgment. Westlaw will tell you it's being appealed. It's not being appealed, but Westlaw hasn't. The permission was granted by Mr. Justice Lane, but that is not that. There is no application for permit. There's no appeal. Apologies, before the Court of Appeal. And then the case of Ali, which again is a decision of Mr. Justice Lane, which David and I were instructed in. That's about the requirement under the EU settlement scheme to show dependency at the time of an application, and whether that reflected the requirements of the withdrawal agreement. So that claimant had come to the UK in 2014 when she was 19 as a dependent family member. By the time she made her application under the EU settlement scheme, she was estranged from her family and living independently from them. And her application to the EU settlement scheme was rejected because she was no longer dependent on her mother. And Mr. Justice Lane decided that that was lawful. But as I understand it, there will be an application for permission to appeal. So Just a couple of points to mention here as I'm coming to the end of my time. AT, I've mentioned. MS is a case about social security coordination where permission has been granted to go to the Court of Appeal. The point of interest here is that it may raise an issue about the circumstances in which a reference can be made to the ECJ under Article 158 of the Withdrawal Agreement. Article 158 is in Part 6, and that says that where in a case which commenced at first instance within 8 years from the end of the transition period, before a court or tribunal in the UK, a question is raised concerning the interpretation of Part 2 of this agreement, and where that court or tribunal considers that a decision on that question is necessary to enable it to give judgment, that court or tribunal may request the Court of Justice to give a preliminary ruling. And one of the grounds of appeal is that the upper tribunal wrongly didn't make a reference in that case. Now, the Secretary of State's answer is, well, that there is no basis for making a reference because this concerns law before the end of the transition period, because it's a decision before the end of the transition period, so it can't be about interpretation. But in any event, there's no need for a reference because the law is clear. So that's the MS case. I don't think it has a listing quite yet, but I understand it's a bit to be listed soon. And then I've noted on the slide some other Siddiqa and Batul, which Galina will deal with, and then the case of, I'm not sure how you pronounce it, Rexhaj, which concerns whether the grant of entry clearance under Appendix EU family permit, because there are two, Appendix EU family permit and Appendix EU, does a grant of entry clearance under Appendix EU count as leave to enter? Sorry, does a grant of entry clearance under Appendix EU family permit count as leave to enter under Appendix EU? And it mattered in that case because it affected whether the applicant mother needed to show dependency to succeed. And the upper tribunal said that the entry clearance did count as leave to enter, and the Secretary of State has applied for permission to appeal to the Court of Appeal. So what's next? I've been going through some points as I've been speaking, lots of issues about rights of family members. Galina will address those. I've mentioned the Rexhaj case. The other case to mention is a case which is listed at the start of next year in the Court of Appeal about an extended family member whose passport was stamped at the border as admitted under the EEA regulations, but in fact the Home Office cases, but there was no power to admit that person. And so the ultimate issue is, are they within scope of Article 10, 2 and 3 of the Withdrawal Agreement? And Galina will be dealing with those provisions more generally. Criminality cases, there are at least 4 pending appeals in the upper tribunal. They're going to be heard in, I think, the beginning of November, and then another one in mid-November about appeal rights and various other issues to do with criminality. Those issues include the extent to which withdrawal agreement arguments can be raised in an Article 8 appeal. There's also a pending decision about the policy of pausing decision-making on certain EU settlement scheme applications where there's a pending prosecution. I don't think there's been a decision in that case yet. Cases about Zambrano and the EU settlement scheme and the requirement not to hold leave under another route. So under the EU settlement scheme, although Zambrano carers are not covered by the withdrawal agreement, they are catered for under the EU settlement scheme. But if they hold leave under another route, or they could qualify under another route, they won't qualify under the EU settlement scheme. The case of Akinsanya went to the Court of Appeal last year. That's about the scope of the Zambrano right in EU law and in the domestic legislation. And now that case and another case is listed, or likely to be listed, to deal with issues about the withdrawal agreement. And there are many more issues, some of which Charles and Galina will address, and again, which I could talk about for another 20 minutes. As usual, I've gone slightly over time, so thank you for listening to me. And I will now pass over to Galina.
Thanks very much, Julia, and good morning, everyone. The purpose of my talk is twofold. Firstly, I'm going to outline as best I can the position for extended family members under the withdrawal agreement, and the applications that need to be made to obtain rights of residence in this country. And secondly, in doing that, what I'm really doing is setting the stage for Charles's presentation on how complex all of this is. So let me just get control of the screen. There we go. I'm just going to start with who is an extended family member. And to understand how this all works, we need to go back to the Citizens' Rights Directive and the definitions there. Now, under Article 2 of the CRD, family member is defined as a spouse, registered partner, direct descendants under the age of 21, or direct descendants who are dependents, and that was the issue in the Ali case that Julia talked about, or dependents in the ascending line, so dependent parents, etc., which is the Rex Hatch case that she also talked about. Those people defined as expressly as family members, and therefore by Article 3.1 of the directive applies to them as it applies to the Union citizens themselves. Article 3.2 of the directive then extends, hence the term extended family members, to other family members, as I've set out on the slide there. Firstly, so family members not falling within Article 2, who either are dependent on the Union citizen or members of their household in the country from which they have come, or where they have serious health grounds that strictly require the personal care of the family member by the Union citizen, or, and this is where an awful lot of the case law, of course, that many of you will be familiar with, comes from, the partner with whom the Union citizen has a durable relationship, duly attested, so unmarried partners. And the rights to conferred on extended family members under the CRD, well, first of all, let's go back, set out in the opening text of Article 3.2, are that the host member state, in accordance with its national legislation, shall facilitate entry and residence for those persons. And Article 3.2 ends by saying that the member state must undertake an extensive examination of the personal circumstances and justify any denial of entry or residence to these people. So what does that mean? It doesn't mean, or it didn't mean, that member states are obliged to necessarily to grant entry or residence to extended family members, but it did mean that they had to confer an advantage on extended family members as opposed to other third country nationals when they applied for a right to reside. And that application had to be dealt with in accordance with national legislation. The member state has discretion on the criteria that might be imposed under that national legislation, but there's various bits of case law in the CJEU that touch on the limits of that discretion. Most importantly, the case of Rahman that I've put on the slide there, which established that the criteria must be consistent with the normal meaning of facilitate and the normal meaning of dependence, and so not deprive the terms of the directive of effectiveness. And the Bangor case, which made absolutely clear that there must be an effective judicial remedy against any refusal. So it's not quite as clear as the position of what might be termed direct Article 2 family members, but there is a right to make an application to have it considered against criteria that conform to the requirements of the directive, and to have a right of appeal against any refusal. And in the UK, those requirements were ultimately implemented by the 2016 regulations, which I've put, just put the title up on the slide. Under those regulations, you could apply either for a family permit to join the Union citizen from abroad, or if you're already here, for a residence card. And this is where the term that Julia struggled with, and I'm not sure I'm going to do much better, but I'll try, constitutive versus declaratory rights becomes important. So if you're a union citizen or direct family member under Article 2, your rights just exist. You don't have to do anything to obtain them. Extended family members seeking facilitation under Article 3.2, that was sometimes referred to as a constitutive system. So you didn't have any rights until you applied for and were granted the right of residence. And under Regulation 21 of the 2016 regulations, there was a fairly strict set of requirements for what an application had to look like and what information had to be included with it. And an application not made in that form had to be treated as invalid. But of course, pre the withdrawal agreement, pre the UK's exit from the EU, it was always possible to simply make a fresh application if your application felt to be rejected. So where are we now with the withdrawal agreement? Julia set out the structure of the withdrawal agreement. And as she said, Article 18 established, entitles member states and the UK to introduce something that looks a bit like, say, whether that's exactly the right term is up for grabs, but something that looks a bit like a constitutive scheme, so that you have to apply for your rights of residence to be recognised. And then there are various requirements in Article 18 about if you choose to introduce such a scheme, what that scheme has to look like. And of course, the UK has chosen to introduce such a scheme, and that's the EUSS, which we'll come on to in a moment. Interestingly, Article 18 only applies to the rights within this title, and those of you with photographic memories at least will recall from Julia's slides that Article 18 sits in Title 2 of Part 1 of the Withdrawal Agreement, whereas Article 10, which is actually the only place where there's any mention for these purposes of rights for extended family members, falls within Title 1. It's been suggested in open court that that might have been just a typographical error or mistake in the withdrawal agreement. Not sure, but in any event, Article 18 does, on its face, include reference to people who fall within Articles 10.2 and 10.3. That's in Article 18L, and what can be required of them. So although the rights, the substantive rights, come from Article 10, there is at least some indication in the withdrawal agreement that all of this falls within the requirement, or is governed by the requirements of Article 18. Now, what does Article 10 actually say in relation to extended family members? As Julia said, Article 10.1 lists out the union citizens and their direct family members who are within the personal scope of the withdrawal agreement. And then by Article 10.2, first of all, that's extended to people falling within A and B of Article 3.2 of the Citizens' Rights Directive. So that's the people, the dependent relatives and durable partners whose residence was facilitated by the host state before the end of the transition period. So if you'd already made your application and it had been granted, you're within personal scope of the withdrawal agreement, and you can make your application for a residence document. And that'll be governed by Article 18. Article 10.3 further extends that to people who had already applied for facilitation before the end of the transition period, and whose residence is being facilitated by the host state in accordance with its national legislation thereafter. Now, slightly difficult wording, but we think that applies to people who had applied before the end of the transition period, whose application had not been determined by the end of the transition period, up to the point at which the application is determined, and if it's, of course, if it's determined in their favour, then they're squarely within Article 10.3. If it's determined against them, they were, of course, entitled to rights of appeal. That's the Bangor case that I referred to and provided for under the 2016 regulations. So the protection would seem to extend to them for that little bit longer. We then have Article 10.4, which is about applications being made from out of country before the end of the transition period. And then Article 10.5 makes clear that, as was the case under Article 3.2, when those applications are made, the host state is required to undertake an extensive examination of the personal circumstances of the persons concerned and to justify denial of entry or residence to such persons. So almost word for word, the same as the closing words of Article 3.2. And Julia touched on Article 4, an interpretation of the withdrawal agreement. It's not contentious that those terms have the same meaning here in Article 10 as they did under the pre-withdrawal agreement citizens' rights directive case law, so Rahman and Banga, etc. So that's the position under the withdrawal agreement. As we know, the UK has set up a scheme under Article 18, the EUSS, and the key part of that, or the key term there for the purposes of applications made by extended family members, is that to fulfil either paragraph EU 11 or EU 14, which are the limited and indefinite leave provisions, one of the criteria is that the person, so one of the categories of person that can apply, is a family member of a relevant EEA citizen. And the definition of family member of a relevant EEA citizen is to be found in Annex 1 to Appendix EU, which sets out the EUSS. That's a very long annex with a lot of definitions. For our purposes then, this definition, family member of relevant EEA citizen, covers, of course, spouse or civil partner, as long as they were either married before the specified date, which is the end of the transition period, or were durable partners before that date. Covers durable partners, again, as long as partnership was formed and was durable before the specified date and remains durable at the date of application, and covers children or dependent parents of the relevant EEA citizen if that family relationship existed before the end of the transition period. And finally, the dependent relatives that were also covered within Article 3.2, who were either dependent or member of the household in the country they came from, or who have a strict need for personal care on serious health grounds. So that sort of seems straightforward enough, but it's not enough under the terms of the EUSS simply to show that those conditions are met as a matter of fact. In each case, there's a further definition within Annex 1 to Appendix EU. Firstly, for durable partner, a person is only a durable partner if they hold a relevant document as the durable partner of the relevant EEA citizen for the period of residence relied upon. There is the caveat there that if the relevant document had been applied for before the end of the transition period and is subsequently granted, they're deemed to have held it since immediately before the end of the transition period. So it has retrospective effect to the extent that they are deemed to have been in the durable partnership, to have met the definition of durable partner before the end of the transition period. Sorry, wrong way. And similarly with dependent relative, they must hold a relevant document as the dependent relative of the sponsoring person for the period of residence relied upon. And the period of residence relied upon, I'm sure you'll recall, must be before the specified date. So in order to qualify as a family member, or in order to fulfill the criteria in Appendix EU as a family member, if you're an extended family member, you must have had, or at least have applied for, your relevant document under the 2016 regulations before the end of the transition period. So, of course, there was a period where, for the end of the transition period in particular, where these two schemes were running in parallel. You could apply to, under the 2016 regulations, up until the end of the transition period, and indeed for an extended period after that, in particular in relation to out-of-country applications. So those applications could be made, but the EUSS, as we all know, was up and running some time before the end of the transition period. And the government's position clearly stated in litigation, if not, and there's some debate about this, entirely clear from the guidance that was issued at the time, was that you had to make that application first under the 2016 regulations. Once you have that document under the 2016 regulations, then you could apply under the EUSS. It's just worth noting that applications made under the 2016 regulations, if they weren't determined before the 30th of June 2021, then you wouldn't actually get a document that fulfilled the then current definition of relevant document in the EUSS. You just get a letter from the Secretary of State saying that you met the criteria, and the EUSS has subsequently been amended to include that letter within the definition of relevant document. As you might imagine, there was quite a bit of scope for individuals to get a bit lost in that process and to end up making the wrong application. And a particular issue, of course, is where people went straight to the EUSS, made their application for leave to remain as a durable partner, as a dependent parent, as a child under the age of 21, and hadn't previously made their application under the 2016 regulations, and so didn't have the relevant piece of paper. The Secretary of State's response to such applications has been very much, computer says, no, you don't have the right piece of paper, therefore you cannot succeed under the EUSS, you cannot have any grant of leave. And a number of arguments have been run in a few of the cases that I've listed here that Julia's already mentioned, seeking to soften that position for applicants who haven't applied under the 2016 regulations, but who quite clearly in some of the cases do meet those criteria, or at least, as we would say, are entitled to consideration under Article 10.5 of whether they do. The first of those cases was Batul. As I understand what went on there, the applications that were made were on the basis that the applicants were direct family members within Article 2 of the Citizens' Rights Directive, and they were arguing that they should have been treated, in fact, as having made applications on the basis that they were extended family members, which they were. But their applications were refused, the appeal was dismissed in the upper tribunal, and permission to appeal to the Court of Appeal was refused. However, in Selic, the case did get to the Court of Appeal. That was a case in which the appellant was a non-EU citizen. He had been in a relationship with a Romanian citizen, admittedly only from the beginning of 2020, and his case was that he would have got married to her during 2020 and therefore been able to make a very straightforward application as the spouse of an EU citizen who married before the end of the transition period. But the COVID pandemic got in the way. As we all know, there were some restrictions on weddings during that year. So he had made an application before the end of the transition period when he was not married to his future wife under the EUSS on the basis that he was in a durable partnership with her. And that, of course, was refused because he hadn't made the application under 2016 regulations. And he sought to run a number of grounds of appeal based on the unfairness of the position that he found himself in. But on behalf of the IMA, and this was an argument that was also run by the Air Centre and Here for Good intervening in his appeal in the Court of Appeal, we tried to run an argument that having made that application under the EUSS was in substance an application for facilitation of his entry in residence as a durable partner, and therefore brought him within Article 10.3 and therefore required proper consideration as set out in Article 10.5, not just an automatic refusal for not having the correct document under the 2016 regulations. Now, the Court of Appeal in that case ended up holding that the question didn't arise on his facts, and that was effectively because he hadn't appealed that first decision to refuse his application under the EUSS as a durable partner. He'd waited, made another application as a spouse after the end of the transition period, and that was the application that had given rise to the appeal that reached the Court of Appeal. And so the court didn't want to, declined to decide that issue in a case where they felt it didn't arise, and where it's perhaps right to say that the facts were less favourable than they might have been. But don't give up, because in Sadiqa, the last case on that slide, which I think Julia gave you the reference for, I seem to fail to put it on my slide, but in Sadiqa, permission to appeal to the Court of Appeal has just been granted to run effectively that argument again, in a case where it does arise, albeit in the context of an application made out of country for a family, not for a family permit under the EUSS, but should have been for a family permit to enter the country as the Secretary of State's case. And what happened there was the family simply chose the wrong option on the drop-down menu on the website. So the argument that's going to be run is that it's applying general principles of EU law wildly disproportionate for them to end up with no rights at all when they had asked for consideration of their position as extended family members, just not quite on the right form. So as Julia said at the end of her talk, watch this space, there's going to be more litigation. And on that subject of the complexities and more litigation, I will hand over to Charles.
Good morning, everyone, and thank you, Galina and everyone else, for that introduction. And it's really nice to see many former colleagues and ILPA members on the call who I've worked with on some of these issues in the past. Picking up from what Galina has just been highlighting in relation to extended family members, I mean, I don't think this is a controversial proposition that the immigration rules in relation to EU settlement scheme and really across the board are very complicated, quite confusing, quite difficult to read. The causes of that, myriad causes, are not seeking to criticize anyone, but I think it's a fact that when you've got provisions such as the ones I've included on this slide, that is not something that many individuals without lawyers are able to read very easily and understand. And certainly even lawyers struggle with this, and even judges struggle with this, as I will come to. And actually there's a decision of the Upper Tribunal in January this year. It wasn't reported, but has been picked up in various immigration circles, where Upper Tribunal Judge Canavan was pretty scathing, to be honest, about the drafting of the immigration rules, and said things like some parts are barely comprehensible, that the Secretary of State's own representatives are not able to explain the meaning, dense and impenetrable, confusing, difficult to decipher. And this is the part I wanted to pick up on, the last sentence of this paragraph. Some parts of the rules relating to the EU settlement scheme are so difficult to comprehend that it is at least arguable that they lack the clarity of law. There are many other examples of judicial criticism outside of the Appendix EU context, but the panelists, we were all discussing this just before the seminar, and it's regularly comes up in hearings that judges struggle with understanding what Appendix EU is getting at sometimes. Now, this is not a phenomenon peculiar to Appendix EU. It's something that has been widely accepted by government, that the immigration rules are complicated, need to be simplified. The Law Commission was commissioned to report on this, and there has been an ongoing project of simplifying the immigration rules. Slightly peculiarly, that has led to there being two sets of rules in the immigration rules now, where you've got some simplified rules, which are in separate appendices at the end of the immigration rules, and the earlier non-simplified provisions still in place as transitional provision, and partly because this is an iterative process, and to overhaul all of the rules at any one time would have been very challenging for the Home Office to do. And so, you know, in fairness, then that isn't a very straightforward task. So that's the position there. But the Law Commission report came out after the Appendix EU had been drafted, and I don't think that there's any intention of redrafting the provisions of Appendix EU. So we've got what we've got. And then just to sort of pause as well, complexity is dangerous and complicated and difficult for applicants, but so too can oversimplicity be. And there was the Advertising Standards Authority in 2019 banned a Home Office advert, which was essentially overly simple, which said all you need to do to apply to the EU settlement scheme is you need your passport and your ID card and to complete an online form. I think the thrust of the slide so far has shown that was not quite right. Home Office said it was implicit in their advert that won't apply to everyone. Advertising Standards Authority thought it was too misleading. But that goes to show that when you're trying to draft rules, you can only be as simple as the policy underlying it is. And the reality is EU free movement law is complicated as well. And so trying to create a scheme that translates that complexity into a new domestic framework that will have longevity for decades to come is not going to be a straightforward exercise. So the question is, we know that the law is complex. We know that judges don't like it. Well, what does the law say about this? What can people do about it? Regularly, practitioners complain about the complexity of Appendix EU, but is that all it is? Is it just a complaint, and do we just have to put up with it? Or are there some things that the law has to say about this that might be relevant in certain cases? So turning to the common law, and immigration rules, which is what Appendix EU is part of, are not a statutory instrument. They're probably not delegated legislation. There's some complexity in the law around that. They are considered to be statements of administrative practice, but they have a status that's slightly higher than just mere policy and mere guidance in other public law contexts, because immigration rules are taken to be approved by Parliament, in that they can be struck down by a negative resolution of Parliament. Now, there's no freestanding ground of judicial review that immigration rules or other decisions of public authorities must be clear, and they must not be confusing, and they must not be based on rules that are not confusing. But there have been examples historically in the quite distant past of rules being struck down as being partial or unequal in their operation, manifestly unjust, made in bad faith, oppressive, etc. But in sort of recent history, that isn't quite so common, and really practitioners have turned towards the Human Rights Act to raise those kinds of arguments. But the common law has other principles that might be relevant that draw on the complexity. And so, for example, the principle of legality. Principle of legality is that when a court is interpreting a piece of legislation, it must do so so far as possible to ensure that it complies with fundamental rights as protected by the common law. If there's ambiguity in the legislation, then that is resolved against breaches of fundamental rights, because the idea is that if Parliament is intending to be breaching fundamental rights, it would have done so expressly. Whether that applies in the immigration rules context, I'm not aware of there being any case that actually has decided that, but generally the principle of legality is seen as one of statutory construction, can also apply to legislation, but that's a sort of complex public law issue. And whether or not it could be said that any fundamental rights as protected by the common law are engaged by the immigration rules, especially the ones relating to Appendix EU, I'm not so sure. The principles of statutory interpretation also include principle of construction of statutes against absurdity. And there are many subtenets of that, to avoid capricious results, to avoid silly results, inconsistent results, illogical results, referring back to the purpose of the legislation. When interpreting a provision that is overly complex, then, or overly obscure, then there might be relevant arguments about whether or not those doubts over how ambiguity should be resolved in favor of one way or the other. And just sort of more particular to the drafting style, but maybe less powerful as an argument, is there has been in the past judicial consideration of the extent to which they need to take into account how good the legislation drafting is. That primarily related to when Parliament was passing legislation that was not very well drafted before the creation of the Office of Parliamentary Counsel in the 19th century. And it isn't so relevant now, because now we do have very professional, very experienced body of parliamentary counsel who draft these things, draft legislation. I'm not aware that they draft the immigration laws, and maybe I can be corrected on that. But there has been case law which has called into question the quality of the drafting, and that has been relevant to how it is then interpreted in later cases. So that's been repeated at the top slide, but just pausing on one point that arose in the Ali case that Julia mentioned. In that case, there was essentially a straightforward Wednesbury unreasonableness challenge to a provision in Appendix EU. And what was interesting is that the complexity of the arrangements arising from the departure from the EU and how that would work in domestic implementing legislation was actually a reason against finding Wednesbury unreasonableness, because what the court said was, well, this is really hard. We've got to trust the government's judgment on how they're going to manage this process. So then looking at retained EU law and what the withdrawal agreement says. Now, Galina has already looked at Article 4.3 of the withdrawal agreement, which relates to the general principles of union law. They are part of the agreement, or the agreement needs to be interpreted and applied in accordance with those general principles, and the IMA decision accepts that principle also. The most relevant general principle of EU law is one called legal certainty, which applies to the interpretation of the withdrawal agreement. How far that would extend to interpretation of Appendix EU and decisions made under that is a bit of a more complicated question, but it's certainly open to argument. So what is legal certainty within the body of EU law? Well, it's an aspect of the rule of law. It's a principle recognised since 1961, regularly invoked by the Court of Justice, but case law is actually somewhat ironically inconsistent and a bit murky on this. Some of the basic tenets are rules of law must be clear, precise, and predictable as regards their effects. The application of rules of law must be foreseeable by those subject to them. But more generally, it's about it's used to import other administrative law concepts like legitimate expectation and a prohibition on a non-retrospective application of law. So you can't apply a law to something that's happened in the past when it wasn't law at the time. And so it's unclear the extent to which general principles inform the EU settlement scheme going forward, for the reasons I've outlined about the relationship between the immigration rules and the withdrawal agreement. So turning then to final body of law, which is the European Convention on Human Rights. Now, European Convention on Human Rights has created a very, very rich jurisprudence on something called quality of law. And that stems from provision in Articles 5, 8, 9, 10, and 11, so relating to interference with private life, freedom of expression, freedom of association, freedom of religion, etc., which says that any interferences with those rights must be prescribed by law or in accordance with the law, before moving on to the proportionality analysis. Whether something is prescribed by law or in accordance with law, the two concepts have been treated to be the same. And what that means is that the measure that is creating the interference with the convention right must have some basis in domestic law, well, we know that the immigration rules do have a basis in domestic law because the Immigration Act 1971 probably is the source of the right of that. See various Supreme Court decisions which have toyed around with where that might come from with a part of the power to pass the immigration rules. See how Alvey and Munir for that. A measure must be compatible with the rule of law, meaning it should be both accessible and foreseeable. So what does accessibility mean? Well, that means it should be published, it should be comprehensible, and it should be possible to discover what its provisions are. Foreseeability means that a person must be able to foresee the consequences for them, and that a discretion, a power to exercise a discretion in respect of an individual, shouldn't be so broad that in practice that discretion is just subject to the whim of the person who's applying it. There has to be some guiding principles that mean that the provision, that the discretion is exercised objectively. So really, for relevant purposes, it's going to be this principle of accessibility, I think, that's most relevant to drafting of the EU settlement scheme and the complexity of the EU settlement scheme, and whether or not it could truly be said that a rule was comprehensible, so that an individual with or without a lawyer was able to understand the extent to which it applied to them. We've seen in the extended family members context, that's really where the bullfight is over that area. So what's the relationship between the European Convention of Human Rights and the immigration rules? Well, there's conflicting case law as to whether Section 3 of the Human Rights Act, which requires that legislation be interpreted so far as possible in compatibility with the so that it is compatible with convention rights. Some cases have said that Section 3 doesn't apply to the immigration rules, to interpreting the immigration rules. But then other cases have said it does apply, but the case law doesn't speak to each other on this. I suspect this will be up for grabs in another case on another occasion, probably not in the EU context, but it possibly could be. But it is not controversial that the application of the immigration rules in individual decisions must respect convention rights under Section 6 of the Human Rights Act. And what's also not controversial is that the court may find immigration rules incompatible with the European Convention on Human Rights in certain situations, but the exact standard that must be applied to determine whether or not an immigration rule is incompatible with convention rights is something that remains to be determined following the contemporary approach to what we call systemic or policy challenges. Following a number of decisions in the Supreme Court in 2021, do you need to show that it happens in the vast majority of cases? Do you need to show that the application of the rule would breach convention rights in a sort of material number of cases? The case law has various ways of approaching this question. So what next? Well, in terms of EUSS appeals, in Selleck, the Court of Appeal looked at this question because an argument was raised that the refusal of leave in that case would have breached the individual's Article 8 rights. But the court there said that Article 8 of the Convention didn't assist in interpreting the scope of the withdrawal agreement and determining the rights granted by that agreement. So when you're focusing on what the withdrawal agreement says, we're not bringing in principles of quality of legislative drafting at that stage. But as the court goes on to say, issues under Article 8 of the Convention may arise when the respondent is considering relevant decisions under the immigration rules. And when taking such decisions, the respondent would be under a duty under Section 6 of the Human Rights Act to act compatibly with any such rights. So an argument might be that by relying on a provision of the immigration rules that was so impenetrable to the applicant that they couldn't understand it, by using that to justify a refusal of an application that has led to a breach of or an interference with an individual's Article 8 rights, private or family life, that was not in accordance with law because the quality of the legislation was not sufficient to be comprehensible to the individual. That might be an argument that could be run. Whether or not it would succeed, well, that's to be determined, I suppose, if it arises. But that would be the situation in which it could arise. And in other parallel judicial review contexts, you might see these issues arising. What was notable in Selleck, though, was that actually Article 8 didn't come into it because the appellant did actually obtain leave under Appendix FM, and so there hasn't actually been any interference with Article 8, because so the court said, because family was actually united through some other way. Also look at Batul for how ECHR arguments can be raised in EUSS appeals. It basically depends at what point in the process Article 8 arguments might have been raised. And I just would finally note that one thing to think about when thinking about legal certainty, complexity of the rules, is the relationship between complexity, understanding the law, making the right application, complying with the rules, and who is most likely to be affected by a rule that's very complicated. That's likely to be more vulnerable people, people who have got less support to assist them to make the right application, and that could involve ideas of anti-discrimination, Article 14 ECHR, but also the principle of non-discrimination within EU law. So whether or not this will come up in other cases, not sure, but I think there are certainly ways in which the law has things to say about complexity of the EU settlement scheme. So that's my talk, and I think we now will be taking some questions, and I can see there've been a lot of questions in the chat box.
That's right, we'll move to questions now. But before we do, can I just begin by saying an enormous thank you to all the presenters, Julia, Galina and Charles, for those three really fascinating, extremely interesting talks. Certainly for my part, I learned an enormous amount from that, and that all the talks touched on a variety of issues, some of which have troubled me in the past, some of which no doubt will trouble me in the future, and I will be keeping those slides in a very safe place and close at hand for the next time I have to deal with one of these issues. So many, many thanks indeed to the three speakers. In relation to Charles' speech, the last one that you've heard, and having been on the receiving end of some of the Court of Appeal's frustration about the complexity of the rules on previous occasions, I have in mind a particular case called Singh and Khalid about the transitional provisions in the rules many years ago, where I got a very bad-tempered Court of Appeal late on a Tuesday afternoon, I think. I have some sympathy with that issue. It's very difficult because I think it's a problem that arises in part from the conflict between trying to have a closely rules-based system which is as predictive and as sort of clear as possible in terms of trying to predict future possibilities, coupled with the fact that it's dealing with human beings. And it's the tension that I think runs through the immigration rules and the immigration system more specifically. And you see that coming out in a number of areas of immigration, or obviously, as Charles said, not just the EU. I've also noticed an increasing number of cases where the issue about certainty and the ECHR, quality of law, the quality of law issue that Charles mentioned, is starting to be dealt with now. For example, in a number of national security cases around deprivation, it's a sort of an increasing issue in public law and human rights cases generally, I think. Anyway, on to the questions. We've had some very, very good questions. We're going to start with a question and its development from Simon Howells. I'll just quickly read out the main part of the question. He's asked if anyone has any thoughts on Articles 8 and 14 discrimination arguments about difference in treatment between third country nationals and those with pre-settled status who've been subject to domestic violence, and those, on the other hand, who have leave under the Appendix FM of the immigration rules. The latter have the destitute domestic violence concession, whereas those with pre-settled status do not, or at least not without abandoning their EUSS applications. And he's talked about the contrast there. So I'm going to start by, and so I should say thank you very much, Simon, for that very good question. I'm going to start by asking perhaps Julia if she has anything she wants to say about that.
Hi, Simon. Yes. First of all, it's an issue in the background in AT. There is a stayed discrimination claim in AT. Whether or not that will ever be decided will depend on what happens in the AT litigation in the Court of Appeal. So that's the first point. The second point to make is that there is other litigation on this issue, although there isn't that I don't think it's sort of got very far. But beyond that, I probably won't say any more. And we'll see if Charles and Galina would like to say anything.
Well, I mean, so the question is about the difference in treatment between third country nationals with pre-settled status who've been subject to domestic violence and those who have leave under Appendix FM of the immigration rules, because those under Appendix FM have got the destitute domestic violence concession. There was a Court of Appeal judgment earlier this year, SWP, which was about the difference in treatment between someone under Tier 2 of the immigration rules and people under Appendix EU of the immigration rules, because those, from my understanding, and I'm not sure if this is what Simon was getting at, but from my understanding, those with pre-settled status under Appendix EU are included within the DVILR provision of the immigration rules. I'm not sure whether Simon is potentially getting at a separate, smaller cohort within that group who are not who are excluded for some particular reason. But in essence, though, what the Court of Appeal said in the SWP case is that there's a difference in expectation between people who are on Tier 2 and under Appendix EU as to how long they'd be able to settle in the UK, and that justified the difference in treatment. So I think any argument about this would have to grapple with SWP and to say why it's different from SWP.
Yeah. So just to add to that, this is something I can recall trying to litigate, I think about 15 years ago, in the context of a woman with a retained right of residence, I think, who is a victim of domestic violence, and the difference between, obviously, her position and a victim of domestic violence who'd been here under what was, I think, pre-Appendix FM immigration law. And it would run up against the same barriers. If that is, in itself isn't actually a new issue, the difference between the rights that you get under EU law or the Withdrawal Agreement and the rights that are granted under the rest of the immigration system. But it is one that potentially comes into sharper focus now that they're being merged in this way.
Thank you very much, all of you, for that. Galina's comment about her case 15 years ago, I think proves one of my favourite ideas about the law, which is that law, like politics and football, is cyclical. These things come round and round again, usually in slightly different forms. Thank you very much, all of you. There's then a question which I'm going to ask Julia about. Well, I'm not sure how much she'll be able to say about it, which is what the and indeed Julia and Galina, sorry, I should say, what the second hearing on AT is about. Can I throw that your way?
Galina, do you want to answer that, or shall I?
Well, it's no great secret, because it was live streamed, that there was a draft judgment circulated in AT, and we were having further argument about some issues that maybe arose from that, but no one in open court was, of course, able to refer to the terms of the existing draft judgment because it's embargoed. So we can't tell you what it said, or what you can work out for yourself what the arguments might have been about by watching it on the live stream. So it was in open court. It's a very odd situation, to be honest, and one that, outside the scope of this talk, really, is just a very confusing situation about embargoes and the court's recent strictures about respecting them versus what it actually expects you to do when it holds a hearing of that kind. But we can't tell you exactly what the hearing was about, because that would involve breaching the embargo. Sorry.
Thank you very much, Galina. Julie is resolutely staying on mute after that, so I'm not going to push her any more on that. And given it involves embargoes, I certainly don't want to go anywhere near that. So thank you both very much for saying what can be said about that. I think probably we're going to stay with Galina, if that's all right, for the next couple of questions which relate to family members. There were a couple of anonymous questions about proportionality under Article 18 and impacts on sponsoring EU family members, a question about durable partners and their position, and also a question from Nicole Masri about whether the extent to which the withdrawal agreement allows for a derivative right to reside with family members not covered under Article 10. So Galina, do you want to perhaps start with those?
But shall I start with the easy one? There's a question about durable partners who were previously here lawfully, and they are specifically dealt with at the end of the definition of durable partner in paragraph B2 of that definition, somewhere buried in Annex 1 to Appendix EU. I recall it being raised during argument in Selic and Julia doing her best to explain to the court what it actually meant. But looking at it cold, it is something of a word salad. But what it effectively says, I think, is that if you were here lawfully and in a durable partnership with an EU national before the end of the transition period, you can apply to stay on the basis that you are still a durable partner, as long as that relationship was in existence before the end of the transition period, and you don't have to have made that application if you had an alternative lawful basis of stay. I think, but stand to be corrected there. But yes, there is in any event, there is some special provision made, yes. The other questions about the proportionality questions, so relying on 18(1)(r) to bring in someone who doesn't qualify otherwise as a family member. Yeah, I think it might be worth a run. Give it a go. Julia won't thank me for it. I'll instruct me. Julia will tell us why we're wrong. It's not something you can answer from the face of the agreement, I think, is the answer. And there are a number of arguments that can be constructed around the withdrawal agreement based on general EU principles. I would probably sound a note of caution that in the context of such a detailed scheme and provision for precisely who is and is not a family member, it might be an uphill battle to say that the omission of one particular category was in itself disproportionate. But context is everything, may depend on the particular fact. So if you've got a particular case in mind, please do feel free to come and talk about it.
Thank you very much indeed, Galina. I'm just going to, I don't think we have time quite to go through all the remaining questions. I'm just going to pick a couple of them out. There's a question from, let me see. There's an anonymous question about the IMA judgment and the Article 18 process being only a gateway, and the fact that withdrawal agreement beneficiaries need to continue to meet the Article 13 conditions, and so on and so forth. And the question, very good question, is what role does Council think the host state has in assessing whether a person continues to benefit from such rights? Well, I was in IMA, so that question might go towards me, but I'll do what I always do in those situations, which is turn to Julia behind me and ask her to answer it instead.
Of course, I'm on mute. Thanks very much for that question. The first thing to say is that for anyone who doesn't know, the Home Office announced on the 17th of July EU settlement scheme enhancements. From September 2023, people with pre-settled status under the EU settlement scheme will automatically have their status extended by 2 years before it expires if they haven't obtained settled status. So that's I can give anyone the link to that who wants it. In fact, and this was part of the government's arguments in the IMA case, which was that one of the points of having a system of leave was to give legal certainty. So what the government position was, what we've done is we've extended the EU settlement scheme, including to people who don't qualify under the withdrawal agreement, and it will allow anyone to know on any given date what somebody's resident status actually is. And unlike the old days, the old EU days, where you would have, for example, a benefits agency, or as you say in the question, a business working out if somebody had a right, usually those benefits, because all EU citizens would have a right to work, so it would more often arise with third country nationals. But the idea was to get rid of that uncertainty, but that uncertainty was absolutely a feature of the old system. The idea was with leave under the EUSS that falls away. But yes, I mean, to the extent that changes by the Home Office don't sort these things out, then that will be something that continues. If somebody is saying, well, I don't have leave under the EU settlement scheme, but I have got rights under the withdrawal agreement. But in reality, that's probably going to end up in court if it matters.
Sorry, that's very helpful, but Charles is going to add to it.
Yeah, I mean, I think something to bear, the question was what role does the host state have in assessing whether a person continues to benefit from such rights? Well, I think the first thing to just think about is there is no duty for the host state to do that. Whether or not the host state wants to do that is up to them. If they want to take any steps to do anything to discontinue someone's status because they consider they no longer benefit from the withdrawal agreement, that would be up to the host state, but there's no obligation for them to do that. So I think that withdrawal agreement is about protecting citizens' rights. Where that might involve going beyond that is a decision for the each individual host state. So that's something I think that needs to be borne in mind.
Thank you very much, Charles. That's really helpful. And Charles, I don't know whether you wanted to maybe pick up another question we have there from Nicole Masri about the lawfulness of recent restrictions imposed by government on making late applications.
Yeah, so this was announced at the same time as the attempts to rectify the IMA judgment. I use the word attempts, but anyway, so this was changes to restricting late applications and removal of administrative review rights from refusals. In terms of removal of the right to administrative review, I'm not aware that causes any sort of legal issue. I think administrative review has always been a sort of peculiar phenomenon that was created by the Home Office as a sort of alternative to appeals. It's really about resolving kind of clerical errors in applications, and sort of something that's obviously wrong should get reviewed. It's obviously one less tool that can be used to help an individual, but I'm not aware of that being a sort of very dramatic thing. But the restriction on making late applications, I think I haven't studied the actual changes to that in any great detail, but the most important thing is always to think about how compatible is that with the overarching requirement under Article 18 of the Withdrawal Agreement to allow for late applications to be made where there's reasonable grounds for doing so. And the more that is cut down, the greater the chance of there being situations where there's a mismatch between what the withdrawal agreement requires and what's happening in the domestic context.
Thanks, Charles. And then just a very final question from Martin Williams. I wonder whether, Julia, you might be interested in answering this one. It's about the personal scope provisions in Article 10 of the agreement, and the fact that they're said to apply to those who've exercised their right to reside in the UK in accordance with union law before the end of the transition period, and then adds the words, as we all know, and continues to reside thereafter. And the question is, does anyone have a view on the meaning of that latter phrase, continue to reside thereafter? What quality of residence is needed? Does it have to be in accordance with law at all? If so, is it in accordance with EU law, or would residence under national law be sufficient? So perhaps I ping that to Julian, and maybe that Charles has something to add to that as well.
Yeah, so this was an issue that came up in the background, Martin, in AT, as you know, and the government position, and then it fell away because the government accepted in the upper tribunal that AT was within scope. But it is absolutely an issue. The government position, as I understand it, is that it does require residence in accordance with the withdrawal agreement. And I suspect, to the extent that it is an issue in the UK, and I think that will depend on what happens with various cases, because given that those out of scope can still qualify under the EU settlement scheme, it will be interesting to see if it ends up being an issue in practice. But it absolutely is a legal issue, and again, I won't say more than that at this stage.
Thank you very much indeed, Julia. Well, I think we've run a few minutes over the allotted time. I think that's probably all we've got time for now in terms of the questions. In fact, I think we've managed to get through pretty much all the questions that were asked. And can I say that the questions, for what it's worth, I thought were really interesting as well. So many thanks indeed to all of you who attended for those excellent questions and for carrying on the really interesting debate. So again, can I just finish by saying an enormous thank you to the three speakers for what I think has been a series of really fascinating analyses of difficult issues that have arisen so far under the Withdrawal Agreement and EU settlement scheme insofar as it concerns citizens' rights. As I say, I will certainly be turning back to their talks in due course to answer questions I have. Thank you all very much, those of you who've attended. Again, fantastic to see so many of you that we already know, and some new people as well. Really wonderful to have such a good turnout. We do hope you will attend some more of these events. As I say, there is the second seminar, the update on EU law, so please look out for that. And again, thank you very much, all of you, for your attendance this morning. I hope you have a good rest of the day. Goodbye.